Now that we've looked at the general pattern of how the federal government grew, we're going to dig into a couple specific national powers under Article 1, Section 8. In this lecture, we'll do the Interstate Commerce Clause, and in the next lecture, we'll do the Taxing and Spending Clause. Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Mostly we focus on commerce among the several states, which we call the Interstate Commerce Clause. This language leads us to a couple big questions. What exactly is commerce? And when is it among the several states? The first Supreme Court justice to give a detailed answer to these questions was Chief Justice John Marshall in 1824. Now, we've already met Chief Justice Marshall. He was the one who wrote the opinion in McCulloch v. Maryland, upholding the National Bank. As we saw, Chief Justice Marshall was a loose constructionist. Just as he read the national powers broadly in the McCulloch case, he did the same thing with respect to the Commerce Clause. This case was Gibbons v. Ogden, and the question was whether the national government could regulate passenger travel on steamboats. Now, a narrow definition of commerce might be only the final buying and selling of goods. A strict constructionist might say that transportation was not itself commerce, it was one step removed from the marketplace. However, Chief Justice Marshall rejected the narrow definition and viewed commerce more broadly. It included all navigation along waterways for business purposes. Gibbons isn't just important in its own area of navigating along waterways, though that is important. More generally, Gibbons set the tone for how the Commerce Clause would be interpreted. It would be construed loosely, allowing the national government to amass more power. With the Industrial Revolution, there emerged a large number of businesses that operated at a single location but sold their goods in a national market. Factories, coal mines, and the like. The question arose whether production would be treated as interstate commerce. During the Lochner era, when the court was expanding the right to contract under the Due Process Clause, it also decided many Commerce Clause cases, and the story is essentially the same. The court was skeptical of economic regulations, and it struck down many national laws. Notably, in the case Hammer v. Dagenhart, the court struck down a national ban on factory child labor. The court's reasoning was that production itself is not interstate commerce. Even if the goods are produced to be sold across state lines, all the production takes place at one spot. The federal government, then, has no role regulating factories, mining, and the like. And then it all changed. Just as Lochner was overturned under President Roosevelt, so too was there a revolution in the Commerce Clause. A reminder, in 1937, FDR threatened to expand the size of the Supreme Court. While we're unable to prove cause and effect, the court started reversing its old precedents and upheld FDR's New Deal programs from then on. By the end of his presidency, FDR had appointed 8 justices even without expanding the court, so his economic ideas were firmly stamped into the judiciary. By the end of FDR's presidency, Dagenhart was dead and buried, and the court had swung to the complete opposite extreme. The federal government could regulate practically any business. The best example of the swing towards national power is the 1942 case Wickard v. Filburn. This case concerned the Agricultural Adjustment Act, which tried to stabilize the price of farm goods to avoid wild price swings like we saw in the Great Depression, when the price of wheat had crashed from $2 to 40 cents per bushel, leaving millions of farmers broke and desperate. Mr. Filburn was a farmer in Ohio. The question in this case was whether the national government could regulate wheat that never left Filburn's farm. Filburn grew the wheat on his property and then fed it directly to his farm animals. The court ruled that even this was interstate commerce. The object of the act was to regulate the national price of wheat. When Filburn grew wheat at home, that meant he was not buying wheat in the open market, which affects national price levels. We need to think not of Filburn in isolation, but in the aggregate. If hundreds of thousands of farmers all grew wheat for their own use, that certainly would affect price levels, and thus interstate commerce. The Commerce Clause thus allowed the New Deal to regulate nearly every industry. It also played a profound role in civil rights. Under Jim Crow, the South had built its society around racial segregation. Everything from schools to buses to restaurants to hotels was segregated by race. From the perspective of the national government trying to end this injustice in the 1960s, this presented two sets of problems. Some segregation, schools, buses, public parks, and so on, were created by the state governments and thus could be addressed using the 14th Amendment. But what about segregation by private businesses? The 14th Amendment specifically protects individuals against their state, but it has no bearing on non-government actors. The Commerce Clause emerged as the solution. Even if the federal government didn't have the power to stamp out discrimination, it did have the power to regulate business. The Civil Rights Act of 1964 forbid discriminating by race or sex in hiring, and it forced businesses that catered to the general public. This included restaurants, retail, hotels, and the like, they're called public accommodations, to serve customers of all races. The Heart of Atlanta Motel, a whites-only establishment, sued, arguing that the Civil Rights Act overstepped national powers. The motel argued that renting a hotel room was a purely local action, not interstate commerce. The Supreme Court disagreed. It upheld the act, saying it was a valid use of the commerce power. Now, the Supreme Court found this to be an easy case. It was unanimous, especially because 75% of the guests at the motel were from out of state. That said, even if the Heart of Atlanta Motel only served guests from the immediate local area, you can still imagine a Wickard v. Filburn style argument that it would be interstate commerce. The Supreme Court also made a broad point. With the railroads and then the interstate highway system, the national economy is now interconnected. Writing for the court, Justice Tom Clark observed, "Conditions of transportation and commerce have changed dramatically, and we must apply these principles to the present state of commerce. The sheer increase in volume of interstate traffic alone means that local business practices have far larger impact upon the nation's commerce than such practices had on the economy of another day." Notice that Justice Clark isn't arguing that the Constitution has changed, it's the facts on the ground that have changed. Maybe a century ago, Filburn's wheat or some Atlanta hotel had no impact on the national economy, but today, with interconnected markets, they do. For decades after 1937, the year of the court-packing incident, not a single law was struck down for overstepping the Commerce Clause. People started to wonder, are there any limits on the Commerce Clause at all? Finally, in the 1995 case, U.S. v. Lopez, the court showed that this power did have an outer limit. It's worth noting that by the time of Lopez, the makeup of the court was vastly different. This was no longer FDR's court. 7 of the justices had been appointed by Republican presidents. U.S. v. Lopez concerned a law called the Gun-Free School Zones Act. This law created a buffer zone around schools. Firearms could not be carried within 1,000 feet of a school. Now, how could that be interstate commerce? Well, the legal theory was that school shootings have devastating effects on children, causing trauma. This inhibits learning, which leads to a weaker national economy. Therefore, guns in schools may be regulated under the Commerce Clause. At long last, the Supreme Court put its foot down and said, come on, if this is interstate commerce, then everything is interstate commerce, and the idea of enumerated powers would be meaningless. Enough is enough. The court struck down the law. Now, 2 notes. 1, it's worth pointing out that state governments would be completely free to ban guns in school zones if they chose. That would unquestionably fall under their police power. 2nd, even Lopez barely limited the national government because a year later, Congress essentially repassed the same bill but with an added clause. The buffer zone would only apply to guns that had been moved in interstate commerce. Of course, nearly every gun has crossed a state line at some point, so the Revise Act more or less accomplished the same thing. The Commerce Clause can be complicated, but here is an oversimplified rule of thumb. In short, economic activity can be treated as interstate commerce, even if it occurs at a single location. Activity that is not directly economic, like carrying a gun near a school, is not interstate commerce. Another example of non-commerce would be non-economic crimes, like sexual assaults. In U.S. v. Morrison in 2000, the court struck down part of the Violence Against Women Act that would have allowed abuse victims to sue their attackers in federal court. Morrison ruled that such cases had to be handled at the state, not the national, level. With these basic guidelines, the Commerce Clause gives the national government vast, but not unlimited, power.